afternoon. Are you Diana Jean Harris? All right, thank you. And your appearance, please, Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Harris for purposes of arraignment, Your Honor.
All right, thank you. So we've got a few files here, Ms. Harris. The first file is 25-01985FY. This is a complaint in the people of the state of Michigan versus Diana Jean Harris. It is alleged, contrary to law, that on or about July 2nd of 2025 at the location of 909 West Holmes Road, City of Lansing, Ingham County, Michigan. The charge alleges that you did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance, cocaine. That is contrary to law. It is a felony. Maximum penalty is up to 4 years.
For years, for under 25 grams of cocaine. Welcome to the world of felony charges, where drug possession penalties are still stacking up like it's 1,999. What do you think, rehab or prison time for nonviolent drug offenses? Drop your take in the comments.
Years and or $25,000. Count 2 alleges at the same date and location that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Rebecca Hare, a police officer of the Lansing Police Department that the defendant knew or had reason to know was performing his or her duties. Contrary to law, also a felony. Maximum penalty 2 years, and for $2,000, a consecutive sentence may be imposed under Michigan law if the assault was committed in a place of confinement or for another violation arising from the same transaction. There is additionally an habitual offender fourth offense notice on the complaint because you have at least 3 prior felony convictions. Maximum penalties may be enhanced from what I originally told you. So, do you understand the charges and the maximum penalties, Ms. Harris?
Ms. Harris says she doesn't understand the charges, and legally, that matters a lot. If someone doesn't comprehend the nature of the accusation, the court can't move forward. This isn't just courtroom formalities. This is a foundational right. What would you do in her shoes?
You understand them, Ms. Harris?
No, I don't.
Well, let me just tell you, I'm not asking if you agree. You're certainly allowed to disagree. As a matter of fact, you're presumed innocent. All I need to know is if you understand the charge and the maximum penalty.
No, I don't.
Okay, so let's try this. The first charge is for possession of cocaine. That is a felony, maximum 4 years and or $25,000. Do you understand that? Ms. Harris, do you understand that charge and the maximum penalty?
No, I don't.
Okay. I'll tell you what, let's just go ahead and take a seat and we'll talk later. Okay? All right, Ms. Harris, let's try this again. I've got 3 files here. Mr. Harris, if you would enter your appearance once more, please.
Yes, Your Honor. Assistant Public Defender James Harris here on behalf of Diana Harris for purpose of arraignment only, Your Honor.
All right, thank you. So we have 3 files, Ms. Harris. The first file is 25-01985FY. This is a complaint of the people of the state of Michigan versus Diana Jean Harris. It is alleged that on or about July 2nd of 2025, at the location of 909 West Holmes Road, City of Lansing, Ingham County, Michigan. The charge alleges that you did knowingly or intentionally possess less than 25 grams of a mixture containing a controlled substance, cocaine. That is against the law. You cannot do that, so the maximum on that felony is up to 4 years and or $25,000. Do you understand the charge and the maximum penalty?
That's so funny. That's a lot.
Ma'am, I'm just asking you if you understand it. I'm not asking you if you agree.
I'm gonna tell you I don't understand none that they just putting on me that wasn't true. I'm not understanding nothing.
She's asking if you understand the language of the charge she just read to you.
I don't understand number CMH, mental health, don't understand nothing. Need medication.
Mental health just took center stage, and that changes everything. In the legal world, if someone is found incompetent to understand proceedings, the case pauses until they're stabilized. This moment could completely shift the trajectory of her case. Stay with us.
He got
Okay.
problems.
Okay, ma'am,
She's gonna
do
be
you
good.
have, listen to me, do you have a caseworker at CMH?
I had a caseworker. Yes, I did. I called I talked to the crisis yesterday. He tried to get me in to get back into my caseworker but no, I don't understand number CMH. They can't take me to the mental hospital. This is help to do my thyroid medicine and the medicines that I need to take for bipolar, PTSD.
Ma'am, Officer Wright, has anyone suggested a PRT?
No one has done anything to me up until this point.
Okay. Okay. So, oh, I'm sorry, go ahead. What?
He hasn't had any issues here at the jail with any of the staff.
Okay. All right. So Ms. Harris, if you are requiring mental health services and you really do not understand what's going on here, then I'm going to have a suggestion that at the minimum, Officer Wright is to have the social worker speak with her and kind of go from there. So we're not going to be able to arraign you today if you don't understand what's going on, because that's not fair to you. You know, and I don't know, Mr. Harris, were you able to speak with her this morning?
I was able to get the information I needed for the intake and to potentially address bond. I did try to explain what the charges were, at least the ones that I saw listed. I did not have case files or complaints when I was speaking with her earlier in the morning, but I did try to explain the charges I saw and the charges I could see off of the court's website, and to a certain degree ran into some of the same issues we are having right now, Your Honor.
Okay.
They're just allegations. That's all that they're allegations.
But
The charges are allegations. So you're being potential allegations, but they're not all. That's all they are allegations. You understand that?
Okay, since you don't understand, what we're gonna do is you're gonna get seen tomorrow. All right, I can't do anything about that because there's nobody here to see you overnight. So what's gonna happen is, excuse me?
mental health, you see me what I have to do to start stringing this? Oh, because I'm a mental health patient. The jail don't have mental health attention to see people.
We're going to have our social worker come up here and talk with you about mental health and see where we need to go from there, is what she's saying. And then if
Somebody
to be seen tomorrow, then you'll be seen.
can somebody from Johnny Road, the mental health people over there, see me? That's all I need to know.
That's why we're going to take the social worker, because she can speak with you.
From Johnny.
Yes.
Because they got my whole private, they know.
She's going to contact CMH.
Okay, that's all I need to know.
And so go back to yourself, and then we'll contact our social worker to do.
Thank you.
So count 1, count 2, and count 3 are identical, and that
Here's where it gets extremely serious. Distribution of child sexually abusive material. These aren't minor charges. They carry 15-year felonies per count. And yes, that's on top of habitual offender enhancements. This arraignment just escalated from complex to critical.
It is alleged that you did distribute, promote, or finance the distribution or promotion of a video or child sexually abusive material. Contrary to law, each of those charges, count 1, count 2, and count 3, the maximum penalty, sir, is 15 years and or $75,000. So do you understand count 1, 2, and 3 and the maximum penalty?
No.
Did you
Can
say
you repeat
no?
that? Can you repeat that?
Count 1, 2, and 3 allege that you did distribute, promote, or finance the distribution or promotion of a video or child sexually abusive material. Each of those charges, 1, 2, and 3, has a maximum penalty of 15 years and or $75,000. Do you understand those 3 charges and the maximum penalties, Mr. Hernandez?
Yeah.
Okay. Now, count 4, 5, and 6 are identical as well. Count 4, 5, and 6 allege that you did knowingly possess child sexually abusive material involving a video. Contrary to law, count 4, 5, and 6 are felonies with a maximum penalty of 10 years and or $50,000. Do you understand those 3 counts and the maximum penalty, sir?
Yeah.
Okay. Now, count 7, 8, 9, 10, 11, and 12 are all basically the same with the exception of the underlying charge. So I don't think you'll have any issues with this either. So count 7 through 11, starting with 7, alleges that you did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit. Count 7, that is child sexually abusive activity, aggravated distributing, or promoting. Count 8 is also for the commit child sexually abusive activity, aggravated distributing, or promoting. And count 9 is again the same with the child sexually abusive activity, aggravated distributing, or promoting. So each count 7, 8, and 9 are identical in that it is a felony, maximum 10 years and or $10,000. Reimburse government for expenses incurred in relation to violation in manner indicated by law. Contrary to law, a consecutive sentence may be imposed for the underlying conviction. So, do you understand count 7, 8, and 9?
Yeah.
Okay, so count 10 and count 11 and count 12 are again very similar. Count 10 alleges that you did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit. And again, 10, 11, and 12 are the same underlying charge, or solicit another to commit child sexually abusive material, aggravated possession. Each of those charges, again, 10, 11, and 12, are felonies. Maximum penalty, sir, 10 years and or $10,000. Reimburse government for expenses incurred in relation to the violation in manner indicated by law. A consecutive sentence may be may be imposed for the underlying conviction. Additionally, sir, there is a second or subsequent offense notice on charge of child sexually abusive material. That means that is a felony with a maximum 5-year mandatory minimum, maximum determined by the principal offense. And finally, there is an habitual offender fourth offense notice because you have a prior conviction or 3 prior convictions. The maximum penalty on this may be enhanced as well, from what I originally told you. So that is a lot of information, sir. So do you understand the charges, the maximum penalties, and the offense notices?
Yeah.
Okay, good. Now, you do have rights, Mr. Henderson, and we're going to go over that. You have the right to plead guilty, not guilty, or stand mute. You have the right to a trial by a judge or a jury, and at that trial, you can present or confront witnesses. If they would not appear, the court can order them to do so. You also have the right to a lawyer, and if you cannot afford one can be appointed for you at court expense. Additionally, you are presumed innocent, and if you are found guilty, it must be beyond a reasonable doubt. Do you understand those rights, Mr. Hernandez?
Yeah.
Okay, good. Now, finally, you have the right to remain silent. Anything you say or write can be used against you, and you always have the right to have a lawyer present with you at any time that you are questioned. You understand that as well?
Yeah.
Okay, good. Then, Mr. Harris, is he applying for an attorney today?
Yes, Your Honor. Mr. Hernandez has made an application with our office.
Okay, thank you. So, Mr. Hernandez, because these are felony charges, you have 2 hearings. Your first hearing, sir, is a probable cause conference scheduled for Friday, July 18th. That is at 8:30 a.m. The second hearing is a preliminary exam scheduled the following Thursday, July 24th at 9:30 a.m. Both hearings are with Judge Kristen Simmons, and you should have the notice to appear and Zoom instructions. Do you have them both?
Yeah.
Now, just to be clear, your notice tells you for the PCC you can appear by Zoom. That means if you have access to a laptop or a tablet or a smartphone, you can appear remotely. But if you don't have access, then you have to appear in person. Do you understand that?
Yeah.
Okay, good. All right, then. Is there anything I've told you that you do not understand?
Yeah, my review of his criminal record does show some felonies. However, I don't see anything. I don't believe I saw anything on there in the past 5 years, and I don't believe I saw anything assaultive or violent in that period either. I do understand. I believe there was a bond recommendation that was sent over that was requesting if I recall correctly, it was a cash bond. If the court is considering following that recommendation and ordering a cash bond, I would ask that the court consider ordering a reasonably low 10% bond, something that Mr. Hernandez has a chance to possibly post, Your Honor. I do not believe that he would be a flight risk or a danger to the community. And I believe that with the proper bond conditions, he could be allowed to be released he could be allowed to be released if the court would consider a reasonably low 10% bond, Your Honor. Thank you.
All right, thank you. So, Mr. Hernandez, the court does look at 2 factors. Are you a flight risk? Are you a danger to the public? You do have some criminal history, and they are similar in nature to what we have here. You have in June 6th of 2018 a conviction of felony child sexually abusive activity, distributing or promoting, pleading guilty to that as well as to a second a count of child sexually abusive material possession only. And again, that's in the same June of 2018. Also, in another matter in 2018, there is a felony using a computer to commit a crime. That is
And now we see the court doing a legal balancing act, acknowledging a 7-year gap in criminal activity, but still imposing a $75,000 bond with strict conditions. GPS tether, no internet, no kids nearby. These are high-stakes terms for someone presumed innocent. What do you think? Fair precaution or judicial overreach?
a plea of guilty on that, as well as another conviction of felony child sexually abusive material possession. So that does present some concern to the court, and I realize and understand it's been 7 years since that conviction, so you have very limited criminal history, but it does, again, the nature of those convictions does concern the court, as well as these charges. But let me tell you, I strongly believe that you are presumed innocent, just as the process works. You are presumed innocent until proven guilty, and again, that has to be beyond a reasonable doubt. So I'm not in any way stating or alleging that you are guilty of these charges. But I do have to protect the public, and I do have to make sure that you appear. So with that being said, the court is not going to set a PR bond. I will set a 10% bond based on, again, the history, however, but the lack of history within the last 7 years. So with that being said, the court is going to set a $75,000 10% bond, again, to ensure your appearance as well as the safety of the public. There are conditions, as you can expect. Mr. Hernandez, no access to the internet. You are not to be in the presence of any children or frequent areas where they may be found. You are not to miss any court dates, and you are not to violate any state or local laws while you are on bond. Additionally, you are not to leave the state of Michigan without permission from the court, and you are not to possess or purchase any firearms, ammunition, or dangerous weapons. You will also have to report to pretrial services so that they can set up pretrial supervision. And I am also ordering no assaultive behavior towards anyone, right? Not one particular person, just any person. Additionally, I am going to order a GPS tether to ensure that you do remain within the jurisdiction of the court. And if you are a low-income individual, you can probably get that on a reduced amount. So is there anything about those conditions, sir, that you...
And just like that, it's over for now. But don't be fooled. Arraignment is just the first step. Probable cause conferences, preliminary exams, and possibly a trial. What would be your judge here? What would be your biggest concern?
Not understand?
No.
All right, then. Did you have anything else for the record, Mr. Harries?
Not from the defense, Your Honor. Thank you.
All right, then you are all set, sir. That concludes your arraignment.